My family's estate planning attorneys had no idea that when they systematically excluded me from meetings about my late husband's assets and treated me like a confused old widow who wouldn't understand the complex financial arrangements, they were actually dismissing Eleanor "Ellie" Chen, the former chief financial officer of Meridian Capital Management, who had restructured over $2 billion in corporate assets, maintained direct relationships with federal banking regulators and the SEC, and could make their entire law firm disappear, along with every dollar they thought they were stealing from what they assumed was just another grieving, helpless elderly woman. Before we dive into how I orchestrated the most complete financial and professional destruction that any estate theft operation has ever experienced, let me paint you the picture they saw versus the reality they never suspected. To them, I was just Eleanor Chen, the quiet 70-year-old Chinese-American widow who barely spoke during the few meetings they bothered to include me in, who seemed confused by legal terminology, who appeared overwhelmed by the complexity of my husband's business empire, and who clearly needed their expert guidance to navigate the complicated process of estate settlement. What they never discovered was that Eleanor Chen had spent 35 years climbing from junior analyst to chief financial officer at one of the most prestigious investment management firms on the East Coast. I had personally overseen the financial restructuring of Fortune, coordinated with federal regulators during major banking investigations, and maintained professional relationships with financial enforcement agencies, securities investigators, and white-collar crime prosecutors who specialized in exactly the kind of systematic theft and legal malpractice that Whitmore Davidson and Associates was about to attempt against my husband's estate. The irony was almost poetic. Here they were, planning to exploit what they perceived as a vulnerable elderly woman's ignorance about financial matters, while sitting across from someone who had spent decades detecting exactly their type of sophisticated financial manipulation in corporate boardrooms and federal courtrooms. They saw confusion where there was strategic analysis. They interpreted my careful questions as cognitive limitation rather than recognizing the systematic information gathering that I was conducting about their methods, their coordination, and their obvious preparation for comprehensive estate theft. My husband, Richard Chen, had built Chen Industries from a small import business into a diversified manufacturing and real estate empire worth over $80 million. His sudden death from a heart attack at age 72 had left me not just emotionally devastated, but apparently in the eyes of Whitmore Davidson and Associates financially vulnerable and intellectually incapable of protecting the business empire that Richard and I had built together over 4 decades of marriage and partnership. What Thomas Whitmore Sr. Part and his associates David Davidson and Patricia Kellerman never suspected was that I hadn't just been Richard's wife for 43 years. I had been his unofficial financial advisor, strategic planning consultant, the analytical mind behind many of the investment decisions that had transformed Chen Industries from a modest family business into a major regional economic force. Richard had always been the visionary and the public face of our enterprises, but I had been the financial architect who made his dreams economically viable and systematically profitable. The cultural assumptions that would prove to be their downfall began with their first assessment of my background and capability. Thomas Whitmore had clearly researched my personal history and discovered that I was born in Taiwan, immigrated to the United States in 1975 as a young woman, and had married Richard Chen in 1981 after meeting him through the local Chinese-American Business Association in San Francisco. What his superficial research failed to uncover was that I had immigrated not as a dependent spouse or traditional housewife, but as a Stanford Business School graduate with advanced degrees in international finance and corporate accounting who had already established herself as a rising star in the American financial industry. The sophisticated legal manipulation that they were preparing to execute against my estate required them to view me as exactly what they assumed I was: a traditional elderly Asian woman whose cultural background and generational conditioning would make me deferential to male professional authority, whose limited English and apparent confusion about American legal systems would make me dependent on their guidance, and whose emotional grief would cloud any judgment about the financial coordination and legal procedures they claimed were necessary for proper estate settlement. Their fundamental miscalculation was assuming that my careful, respectful demeanor during initial meetings reflected intellectual limitation rather than professional assessment. When I asked detailed questions about estate procedures, They interpreted curiosity as confusion. When I requested clarification about legal terminology, they assumed ignorance rather than recognizing systematic documentation of their explanations for later analysis and potential evidence collection. When I deferred to their expertise about complex financial matters, they never suspected they were being evaluated by someone whose professional credentials in financial analysis exceeded their own legal qualifications in estate and probate law. The first meeting that revealed their true intentions occurred 3 weeks after Richard's funeral, when Thomas Whitmore contacted me to schedule what he described as an essential consultation about your husband's business affairs that require immediate professional attention. The timing itself was strategically calculated early enough after Richard's death that grief would still be overwhelming my judgment, but late enough that urgent financial decisions would need to be made to prevent business disruption and asset deterioration that could threaten the estate's value. Thomas Whitmore's office at 450 Park Avenue in Manhattan was designed to intimidate and impress mahogany paneling, expensive artwork, floor-to-ceiling law books, and the kind of old-money aesthetic that projected authority and established competence while making clients feel intellectually outmatched and financially dependent on professional expertise. The seating arrangement in his conference room positioned clients across from attorneys in a way that emphasized the power differential while making note-taking difficult and private consultation impossible during group meetings. Ms. Chen, Thomas had said during that first meeting, using the patronizing tone that I would later ensure was played back to the State Bar Association Ethics Committee, I want you to understand that Richard's business empire is far more complex than most people realize. We're talking about multiple corporations, international partnerships, real estate holdings across 3 states, and financial arrangements that require specialized legal coordination to protect your interest during the probate process. Frankly, most widows find this completely overwhelming, which is why Richard was so wise to establish our firm as the primary legal coordinators for his estate planning. David Davidson, the firm's corporate law specialist, had immediately begun explaining the urgent financial decisions that needed to be made to prevent business deterioration and asset loss during the estate settlement process. His presentation included detailed charts and financial projections that painted a picture of immediate crisis requiring professional intervention, complex legal procedures that would take years to navigate without expert guidance, and systematic risks to my financial security that could only be prevented through comprehensive legal representation and estate management services. Patricia Kellerman, the estate administration specialist, had focused on the emotional burden that financial coordination would place on my grieving process and the practical reality that business management required full-time professional attention that would be impossible for someone dealing with the trauma of sudden loss while adjusting to life without Richard's guidance and support. Her systematic emphasis on my emotional vulnerability and intellectual limitations demonstrated the psychological manipulation that they employed to build dependency while eliminating client autonomy and decision-making authority. The estate management proposal that they presented during that meeting was a masterpiece of legal manipulation, disguised as protective service. The document, which I would later have analyzed by federal financial crime investigators, systematically transferred decision-making authority for virtually every aspect of Richard's business empire to their law firm while providing them with management fees, administrative costs, and consultation charges that would drain hundreds of thousands of dollars from the estate while giving them practical control over millions in business assets. The specific terms of their proposal included immediate power of attorney over all business operations, exclusive authority to negotiate contracts and financial agreements on behalf of the estate, complete control over asset sales and investment decisions, and systematic access to all financial accounts and business records that would enable comprehensive monitoring and manipulation of estate resources. The management fees alone would have cost over $50,000 per month, with additional charges for every transaction, consultation, and administrative service that would systematically drain estate resources while building their firm's profitability through systematic client exploitation. What made their proposal particularly audacious was the systematic way they had structured the legal language to appear protective while actually eliminating my authority over assets that were legally mine through clearly established inheritance law and joint ownership structures that Richard and I carefully coordinated with legitimate estate planning attorneys years earlier. Their protective management was actually systematic theft disguised as legal service, and their simplified estate coordination was comprehensive financial manipulation designed to transfer wealth from a grieving widow to unscrupulous attorneys who specialized in exploiting elderly clients' apparent vulnerability and legal ignorance. The psychological manipulation techniques that they employed during our meetings included systematic interruption when I asked detailed questions, condescending explanations that treated basic financial concepts as beyond my comprehension, and strategic time pressure that emphasized urgent decisions requiring immediate signatures while discouraging careful analysis or outside consultation. Their coordination was sophisticated enough that each attorney played a specific role in building psychological pressure while maintaining plausible professional behavior that would be difficult to challenge or report to regulatory authority. Thomas Whitmore's role was to project paternal authority and establish overall control over the estate planning process. His systematic emphasis on his decades of experience, his firm's prestigious reputation, and his personal relationship with Richard created emotional manipulation that positioned trust in his guidance as loyalty to my deceased husband's wishes and business legacy. His frequent references to Richard's confidence in their firm and his apparent concern for my welfare disguised systematic financial exploitation as compassionate professional service. David Davidson specialized in technical intimidation and complexity creation that made independent financial analysis appear impossible while building dependency on legal expertise and professional guidance. His systematic use of legal terminology, complex financial projections, and urgent business deadlines created psychological pressure that discouraged careful evaluation while emphasizing immediate decisions requiring professional intervention and estate management services. Patricia Kellerman focused on emotional manipulation and gender-based assumptions that exploited traditional expectations about women's financial capabilities and decision-making authority. Her systematic emphasis on my emotional vulnerability, intellectual limitations, and need for male professional guidance reinforced cultural stereotypes while building justification for comprehensive estate control and financial management services. The coordination between all three attorneys demonstrated systematic planning and execution that had clearly been developed through previous exploitation of elderly clients whose apparent vulnerability made them attractive targets for legal manipulation and estate theft. Their comfortable assumptions about my intellectual limitations, financial ignorance, and emotional dependency revealed extensive experience with similar operations that had obviously been successful enough to build their firm's profitability and professional reputation through systematic client exploitation rather than legitimate legal service. The moment I realized the full scope of their intended theft was when Thomas Whitmore casually mentioned that the complex business coordination would require my signature on documents that would give them power of attorney over difficult financial decisions, while I focused on grieving and healing rather than worrying about complicated business matters that Richard had always handled. The systematic elimination of my legal authority over my own assets, presented as compassionate protection, revealed the sophisticated criminal operation that they had clearly executed against other elderly clients whose apparent vulnerability made them attractive targets for systematic exploitation. The specific documents they wanted me to sign included irrevocable power of attorney over all business operations, exclusive estate management contracts with automatic renewal clauses, and financial coordination agreements that would give them authority to make investment decisions, sell assets, and negotiate business contracts without my approval or oversight. The systematic transfer of decision-making authority would have made me a passive beneficiary of my own estate, while giving them complete control over assets worth tens of millions of dollars. That evening, sitting in the home office that Richard and I had shared for decades, surrounded by financial documents and business records that told the real story of our economic partnership and my professional capabilities, I began to understand not just their theft of my estate, but their systematic pattern of exploiting elderly clients whose apparent vulnerability made them attractive targets for legal manipulation and financial extraction. The financial analysis that I conducted that night revealed that their proposed management fees and administrative costs would systematically drain over $2 million from the estate within the first 3 years, while their exclusive control over business operations would enable additional extraction through inflated legal services, unnecessary consultation fees, and strategic asset sales that would benefit their other clients or personal investments, rather than the estate's financial interest. The business records that Richard and I had maintained showed clear evidence of my involvement in every major financial decision, strategic planning session, and investment coordination that had built Chen Industries into a major regional economic force. The documentation included my analysis of acquisition opportunities, my coordination with investment bankers and financial advisors, and my systematic oversight of the accounting and financial management that had enabled our business expansion and asset accumulation over 4 decades of partnership. The professional credentials that they had never bothered to investigate included my 35-year career at Meridian Capital Management, where I had risen from junior financial analyst to chief financial officer, while overseeing the restructuring of major corporate clients, coordinating with federal regulators during banking investigations, and developing expertise in financial crime detection and corporate fraud analysis that made me uniquely qualified to recognize and document their systematic estate theft operation. My contact database, from 3 decades of corporate financial management, included relationships with Securities and Exchange Commission investigators who specialized in financial elder abuse, white-collar crime prosecutors at the Southern District of New York, who had handled major legal malpractice cases, and financial crime investigators at the Federal Bureau of Investigation, who coordinated with state bar associations to prosecute systematic legal fraud and professional misconduct. The strategic planning that I began that night included systematic documentation of their criminal behavior, coordination with federal investigators and regulatory authorities, and comprehensive evidence collection that would expose not just their theft of my estate, but their pattern of exploiting elderly clients throughout their decades of practice. The professional network that I had built during my corporate career suddenly became the foundation for the most comprehensive professional destruction that any estate theft operation had ever experienced. But first, I had to let them believe they were succeeding. I had to maintain the performance of confusion and dependency that they expected, while systematically documenting their criminal behavior and building the comprehensive case that would ensure not just my financial protection, but justice for every elderly client they had exploited, and protection for future victims who might otherwise fall prey to their sophisticated manipulation and systematic theft of assets and dignity. The next morning, I called Thomas Whitmore's office and scheduled a follow-up meeting to ask some simple questions about their estate management proposal. My voice carried just the right combination of confusion and gratitude that they expected from a vulnerable elderly widow who needed their professional guidance and protection. What they were about to experience was the systematic unraveling of their comfortable assumptions about elderly vulnerability, legal authority, and the terrible mistake of underestimating a woman whose professional expertise in financial crime detection was about to become their worst nightmare. The performance that I was about to deliver would convince them of my complete intellectual limitation and financial dependence while I systematically documented every aspect of their criminal operation. They would see confusion where there was strategic analysis, dependency where there was professional assessment, and vulnerability where there was comprehensive preparation for their complete financial and professional destruction. The systematic documentation that I was beginning would ultimately expose their decades of estate theft, their coordination with corrupt probate officials, and their violation of legal ethics that had enabled them to build their prestigious firm through criminal exploitation rather than legitimate legal service. What Thomas Whitmore, David Davids, and Patricia Kellerman never suspected was that the helpless elderly widow they were preparing to systematically exploit possessed exactly the professional expertise, regulatory connection, and institutional relationships necessary to transform their comfortable assumptions about elderly vulnerability into the most public and comprehensive legal destruction that any estate theft operation had ever experienced, through criminal prosecution, professional sanction, and civil litigation that would not only recover my stolen assets, but protect countless other elderly victims from their systematic exploitation and abuse. Before we dive deeper into how I systematically documented their criminal operation, while maintaining the perfect facade of helpless confusion, make sure you're subscribed, because tomorrow I'm sharing the story of how a confused elderly nursing home resident who was being systematically drugged and financially exploited turned out to be a retired federal prosecutor, and what happened when she activated her contacts at the Department of Justice for a surprise facility inspection that exposed a multi-million-dollar elder abuse network spanning 12 states. The art of appearing vulnerable while maintaining complete professional control required me to draw upon not just my decades of corporate experience in managing difficult negotiations and hostile takeovers, but my deep understanding of cultural expectations and gender assumptions that the attorneys would use to justify their systematic exploitation of what they perceived as a helpless elderly immigrant woman, whose apparent confusion and dependency made her the perfect target for comprehensive financial manipulation. The persona that I had to construct and maintain was built upon layers of authentic elements that made the deception completely believable while concealing the sophisticated analysis and strategic planning that I was conducting during every interaction. The genuine grief that I felt over Richard's sudden death provided the emotional foundation that made my apparent confusion and overwhelm seem entirely natural, while my actual cultural background and immigrant experience gave me authentic elements to emphasize when I needed to appear less comfortable with American legal systems and business procedure. The physical presentation that supported my vulnerable persona began with careful attention to clothing choices that projected elderly confusion rather than professional competence. The simple black dresses and conservative cardigans that I selected for meetings created an image of traditional widow's mourning, while eliminating any suggestion of the sophisticated business attire that had characterized my corporate career. The comfortable flat shoes and modest jewelry reinforced the impression of someone whose priorities had shifted from professional presentation to basic comfort and practical necessity. My approach to makeup and personal grooming during this period was carefully calculated to suggest fatigue and emotional overwhelm, rather than the polished professional appearance that I had maintained throughout my corporate career. The minimal makeup and simple hairstyles created an image of someone who was struggling with basic self-care during grief, while the occasional appearance of fatigue or emotional fragility reinforced their assumptions about my intellectual capacity and decision-making capability during our legal consultations. The speech patterns that I developed for interactions with Whitmore Davidson and Associates included systematic hesitation when discussing financial concepts, apparent difficulty following complex legal explanation, and the kind of communication uncertainty that convinced them they were dealing with cognitive processing limitations rather than strategic information gathering and professional analysis. My systematic requests for repetition and clarification were interpreted as confusion rather than evidence collection, while my deferential approach to their expertise reinforced their assumptions about my intellectual dependency and professional inadequacy. The memory inconsistencies that I occasionally displayed during meetings included apparent confusion about business details that Richard had supposedly handled independently, systematic difficulty recalling specific financial arrangements and investment decisions, and the kind of cognitive processing challenges that convinced them they were witnessing grief-related mental decline rather than deliberate information management designed to encourage their overconfidence, while gathering evidence about their systematic manipulation techniques and criminal coordination. The technology limitations that I demonstrated whenever they attempted to involve me in electronic document review or digital communication included apparent confusion about computer operations, systematic difficulty with email coordination and electronic signature, and the kind of digital literacy challenges that positioned them as necessary technical facilitators, while concealing my actual expertise in financial software database analysis and electronic document management that I was using to systematically track and analyze their behavior patterns and criminal evidence. The financial management approach that I displayed during our discussions included systematic deference to their expertise about complex estate coordination, apparent anxiety about making financial decisions without professional guidance, and the kind of economic coordination hesitation that convinced them my business judgment had been completely dependent on Richard's leadership, rather than recognizing the strategic financial analysis that I was conducting about their proposed estate management services and systematic asset extraction plans. The banking coordination evidence that they observed during our meetings included my systematic preference for in-person transactions over electronic banking, apparent confusion about modern financial systems and investment coordination, and the kind of institutional navigation difficulty that suggested both technology limitation and cognitive processing challenges, rather than my deliberate strategy of maintaining personal control over financial acts, while documenting their attempts to gain systematic authority over account management and investment decision-making. My approach to legal document review during this period was carefully designed to appear overwhelmed and dependent, while actually conducting sophisticated analysis of their contract language, fee structures, and authority transfer mechanisms. The systematic questions that I asked about confusing legal terminology were interpreted as intellectual limitation, rather than evidence gathering about their systematic elimination of client rights and decision-making authority through carefully crafted contract provisions and power transfer arrangements. The emotional responses that I displayed during meetings included appropriate grief reactions when discussing Richard's death and our business partnership, systematic anxiety about financial security and business management, and the kind of emotional vulnerability that positioned their legal services as protective necessity rather than criminal exploitation. My apparent relief when they offered to handle the complicated details reinforced their assumptions about my intellectual inadequacy while encouraging them to reveal more details about their systematic control mechanisms and asset extraction procedure. The social isolation that characterized my apparent situation included systematic reduction in professional contacts and business relationships, apparent difficulty maintaining community connections during grief, and the kind of social withdrawal that convinced them I lacked oversight or external support that might interfere with their comprehensive estate control and financial management. What they never suspected was that my apparent isolation was strategic positioning that prevented them from discovering my extensive professional network while I systematically documented their criminal behavior and coordinated with federal investigators about their exploitation method. The household management evidence that they observed during home visits included apparent difficulty coordinating domestic arrangements and property maintenance, systematic confusion about service provider management and expense coordination, and the kind of domestic organization challenges suggested both cognitive processing limitations and practical overwhelm rather than my deliberate strategy of appearing incapable of complex coordination while actually maintaining sophisticated business analysis and criminal documentation system. The appointment coordination that I demonstrated included systematic difficulty managing scheduling and time management, apparent confusion about meeting preparation and document organization, and the kind of administrative coordination challenges that positioned them as necessary practical facilitators, while concealing my actual systematic preparation for each interaction, including detailed planning for evidence collection, strategic question and behavioral documentation that would later provide comprehensive evidence of their criminal intent, and systematic manipulation techniques. The medical management approach that I displayed included apparent anxiety about healthcare coordination and prescription, systematic difficulty understanding medical insurance and treatment procedures,
and a kind of health system navigation challenges that reinforced their assumptions about my general cognitive decline and institutional dependency, rather than recognizing my strategic emphasis on health-related vulnerability to encourage their overconfidence about my intellectual capacity and decision-making authority.
The transportation coordination that characterized my apparent situation included systematic preference for assistance with driving and travel arrangements, apparent anxiety about independent navigation and route planning, and the kind of mobility management that suggested both physical limitation and cognitive processing challenges rather than my deliberate strategy of controlling meeting locations and timing, while maintaining comprehensive documentation of their behavior and criminal evidence collection during every interaction. The communication patterns that I maintained with family and friends during this period were carefully managed to support the narrative of overwhelming grief and cognitive confusion, while actually coordinating with my adult children about the systematic documentation that I was conducting and the federal investigation that I was preparing to initiate. My systematic limitation of social contact and professional communication created the appearance of isolation while actually protecting my investigation from discovery and maintaining strategic control over information sharing about the criminal behavior that I was documenting. The financial record keeping that they observed in my home included apparently confused organization of business documents and estate paperwork, systematic difficulty maintaining filing systems and document coordination, and the kind of administrative management that suggested cognitive processing limitations rather than the sophisticated financial analysis and criminal evidence organization that I was maintaining in secure locations, while presenting simplified, apparently confused documentation during their visits and meetings. The business understanding that I demonstrated during discussions about Chen Industries included apparent confusion about operational details and management procedures, systematic difficulty following corporate financial reports and investment analysis, and the kind of business comprehension limitations that convinced them Richard had handled all complex decision-making, while I had been limited to administrative support, rather than recognizing my actual role, strategic financial architect and investment coordinator throughout our 4-decade business partnership. The investment knowledge that I displayed included systematic confusion about portfolio management and financial plan, apparent difficulty understanding market analysis and asset allocation principles, and the kind of financial comprehension limitations that position their estate management services as essential professional necessity, rather than systematic theft disguised as legal protection. My apparent anxiety about investment decisions and systematic deferral to their expertise encouraged them to reveal more details about their intended asset control and extraction mechanism. The legal system familiarity that I demonstrated included apparent confusion about probate procedures and estate law requirements, systematic difficulty understanding court processes and regulatory coordination, and the kind of institutional navigation challenges that convinced them my legal coordination had been completely dependent on Richard's guidance and professional relationships, rather than recognizing my actual understanding of corporate law, regulatory compliant, white-collar crime prosecution that I was using to analyze their criminal behavior and coordinate with federal investigators. The tax coordination approach that I displayed included systematic confusion about estate tax obligations and business tax management, apparent difficulty understanding IRS procedures and compliance requirements, and the kind of tax system navigation challenges that position their legal services as essential professional coordination, while concealing my actual expertise in corporate tax strategy and financial regulatory compliance that I was using to analyze their systematic violation of fiduciary responsibility and legal ethics. The insurance management that they observed included apparent difficulty coordinating coverage decisions and claim procedure, systematic confusion about policy management and beneficiary coordination, and the kind of insurance system navigation that suggested both cognitive processing limitations and institutional dependency, rather than my strategic documentation of their attempts to gain control over insurance decisions and beneficiary management that would enable additional financial extraction and estate manipulation. The property management evidence that I displayed included apparent confusion about real estate coordination and maintenance procedures, systematic difficulty understanding property tax obligations and management requirements, and the kind of real estate system navigation that convinced them my property coordination had been completely dependent on Richard's management, while concealing my actual understanding of real estate investment, property development, and asset management that Richard and I had coordinated throughout our business partnership. The contract coordination that I demonstrated during legal document review included systematic confusion about agreement terms and obligation detail, apparent difficulty understanding performance requirements, and liability provision, the kind of contract analysis limitations that encouraged them to explain their systematic elimination of client rights and decision-making authority, while providing me with detailed evidence of their criminal intent and systematic manipulation technique. The vendor relationship management that they observed included apparent difficulty coordinating service providers and professional relationships, systematic confusion about payment procedures and service evaluation, and the kind of business relationship navigation that suggested cognitive processing limitations, rather than my strategic documentation of their attempts to control all external professional relationships that might provide oversight or interference with their comprehensive estate control and systematic financial extraction. The emergency preparedness evidence that I maintained included systematic anxiety about crisis coordination and safety planning, apparent confusion about emergency procedures and communication protocols, and the kind of crisis management that convinced them my safety coordination required comprehensive professional oversight, while concealing my actual sophisticated emergency planning and communication systems that included federal investigator contacts and regulatory authority relationships that would be activated when their criminal behavior provided sufficient evidence, comprehensive prosecution, and professional destruction. The daily routine management that they observed included apparent difficulty maintaining systematic scheduling and activity coordination, systematic confusion about appointment management and task organization, and the kind of routine coordination challenges that reinforced their assumptions about my cognitive decline, while actually supporting my strategic control over meeting, timing, evidence collection opportunities, and systematic documentation of their criminal behavior and manipulation technique. The community relationship evidence that I displayed included apparent difficulty maintaining social connections and community involvement, systematic confusion about organizational relationships and civic participation, and the kind of community navigation challenges that suggested both social isolation and cognitive processing limitations, rather than my strategic withdrawal from public visibility, while coordinating with federal investigators and regulatory authorities about their systematic criminal operation and professional misconduct. The professional network management that they observed included apparent loss of business relationships and industry connections, systematic confusion about professional communication and coordination procedure, and the kind of professional relationship navigation that convinced them I lacked external oversight or support that might interfere with their estate control, while concealing my actual maintenance of strategic relationships with financial crime investigators, regulatory enforcement officials, and white-collar crime prosecutors who specialized in exactly their type of systematic legal fraud and elder exploitation. This comprehensive collection of daily evidence that supported my vulnerable persona created exactly the foundation that Thomas Whitmore, David Davidson, and Patricia Kellerman needed to justify their systematic boundary violations, while building their confidence that they were dealing with a cognitively declining elderly woman whose limitations required constant professional supervision, rather than recognizing the sophisticated financial analysis and criminal documentation that I was conducting during every interaction, the extensive regulatory relationships that I was coordinating for their investigation and prosecution, or the comprehensive evidence collection that would ultimately expose their decades of elder exploitation to federal scrutiny and criminal accountability. The systematic nature of this evidence accumulation ensured that all three attorneys never questioned the authenticity of my vulnerable presentation, because every aspect of my daily life reinforced the narrative they wanted to believe, while providing multiple confirmation points for their assumptions about elderly limitation and professional dependence. The careful coordination of all these evidence streams created an unshakable foundation for their belief in my cognitive decline, while building their confidence in their authority and control over my estate management, legal coordination, and financial decision-making, confidence that would prove catastrophically misplaced when their systematic legal violations and estate theft extended beyond professional misconduct into criminal behavior that would trigger the comprehensive federal investigation and media exposure that would transform their prestigious law firm into the most publicly prosecuted elder exploitation network in New York legal history. The circumstances that created the perfect foundation for Whitmore, Davidson and Associates to execute their systematic estate theft operation had been building for months before Richard's sudden death. Through a combination of legitimate business complexities, family dynamics, and professional relationships that made me appear increasingly isolated and financially dependent, while actually providing me with the ideal cover for comprehensive documentation of their criminal behavior and strategic coordination with federal investigators about their decades-long pattern of elder exploitation. Richard's business empire had grown increasingly complex during the final years of his life, as Chen Industries expanded from our original import business into diversified manufacturing, commercial real estate development, and international partnerships that created exactly the kind of financial coordination challenges that unscrupulous attorneys could present as overwhelming for a grieving widow, while actually representing sophisticated business operations that I had helped design and coordinate throughout our 4-decade partnership. The manufacturing division that Richard had developed included 3 facilities in Connecticut, Massachusetts, and North Carolina that produced specialized industrial components for automotive and aerospace industry, with annual revenues exceeding $25 million, and contracts with major corporations that required ongoing legal coordination and technical compliance management. The complexity of these operations, including environmental regulations, labor law compliance, and international quality certification, created the appearance of business management that would be impossible for an elderly widow to coordinate independently, while actually representing business systems that I had helped establish and had been monitoring through sophisticated financial analysis throughout their development. The real estate holdings that comprised another major component of Richard's estate included commercial properties in Hartford, Boston, and Charlotte, residential rental properties throughout Connecticut, and development projects in various stages of completion that represented over $30 million in asset value, requiring ongoing management, tenant coordination, and strategic planning for optimization. The systematic coordination required for property management, including tenant relationship maintenance contracts and development financing, provided Whitmore Davidson and Associates with perfect justification for comprehensive estate management, while concealing my actual involvement in property acquisition decisions and investment strategy throughout our business partnership. The international partnerships that Richard had established included supplier relationships in Taiwan, manufacturing agreements in Mexico, and distribution networks throughout Asia that required ongoing legal coordination, currency management, regulatory compliance with international trade regulations. The complexity of these business relationships, including cultural communication requirements and international legal coordination, created additional justification for professional legal management, while concealing my actual role in establishing these partnerships through my cultural background and international business expertise. The family dynamics that contributed to my apparent isolation included the geographic distribution of our adult children, whose successful careers had taken them to different parts of the country and created the appearance of limited family oversight during the estate settlement process. Our eldest son, Michael, was a successful surgeon in Seattle, whose demanding medical practice made frequent travel to Connecticut difficult, while our daughter, Lisa, was establishing her law practice in Denver, and our youngest son, Dave, is completing his MBA program at Northwestern University in Chicago. The perception that these family circumstances created was that I lacked immediate family support and professional guidance during the estate settlement process, making me dependent on legal representation for business coordination and financial decision-making. What Whitmore, Davidson and Associates never suspected was that all three of our children had inherited strong analytical capabilities and were maintaining regular communication with me about the estate settlement process. While my daughter Lisa's legal background provided me with additional insight into probate law and professional legal ethics that I was using to analyze their systematic violations of fiduciary responsibility. The professional relationships that Richard had maintained throughout his business career included connections with accountants, investment advisors, and business consultants who had provided specialized services to Chen Industries over the year. The apparent complexity of coordinating with these various professionals during estate settlement created additional justification for comprehensive legal representation, while the emotional difficulty of maintaining business relationships during grief provided cover for my systematic documentation of Whitmore, Davidson and Associates' attempts to control external professional communication and eliminate oversight that might interfere with their estate management authority. The timing of Richard's death had occurred during a particularly complex period in our business operation, as Chen Industries was negotiating a major contract extension with automotive industry clients, coordinating environmental compliance upgrades at manufacturing facilities, and managing development financing for real estate projects that required ongoing legal coordination and strategic decision-making. The systematic pressure created by these business deadlines provided perfect cover for their claims about urgent legal decisions requiring immediate professional intervention, while actually representing business coordination that I was fully capable of managing through my decades of experience in corporate financial management. The financial institutions that held various accounts and investment portfolios for Chen Industries and our personal estate included relationships with 3 major banks, 2 investment management firms, and several specialized financial service providers that created the appearance of overwhelming coordination requirements during estate settlement. The systematic communication required with these various institutions about account transfers, beneficiary update, and ongoing service coordination provided additional justification for comprehensive legal representation, while concealing my actual familiarity with financial institution procedures and regulatory requirements through my corporate career experience. The insurance coordination that was required following Richard's death included life insurance policies, business insurance coverage, and property insurance management that created additional complexity, requiring professional coordination and claims processing expertise. The systematic documentation required for insurance claims and beneficiary coordination provided Whitmore, Davidson and Associates with additional justification for comprehensive estate management, while concealing my actual understanding of insurance procedures and claims coordination through my corporate experience with employee benefit management and business insurance coordination. The tax obligations that characterized the estate settlement process included corporate tax filings for Chen Industries, personal estate tax coordination, and ongoing tax compliance for business operations that created systematic deadlines, requiring professional coordination and regulatory expertise. The complexity of tax obligations, including multi-state business tax requirements and federal estate tax coordination, provided perfect justification for legal representation, while concealing my actual experience with corporate tax strategy and regulatory compliance through my CFO career at Meridian Capital Management. The vendor relationships that required ongoing coordination during the estate transition included suppliers, contractors, and service providers throughout our business operations who needed communication about payment procedures, contract management, and ongoing business relationships during the ownership transition process. The systematic coordination required with dozens of vendor relationships provided additional justification for professional business management,
while concealing my actual involvement in vendor relationship management and contract negotiation throughout our business development. The regulatory compliance requirements that characterized our business operations included environmental monitoring, labor law compliant industry-specific certifications that required ongoing coordination with regulatory agencies, and compliance consulting throughout the business transition process. The complexity of regulatory relationships and compliance coordination provided Whitmore, Davidson and Associates with additional justification for professional legal management, while concealing my actual understanding of regulatory compliance and government agency coordination through my corporate career experience. The technology systems that supported Chen Industries' operations included financial software, inventory management systems, and customer relationship databases that required ongoing maintenance and user management during the business transition process. The apparent complexity of technology coordination and system management provided additional justification for professional business coordination, while concealing my actual expertise in financial software and database management that I had developed throughout my corporate career in financial analysis and business operations. The customer relationships that Richard had built throughout his business career included long-term contracts with major corporate clients, ongoing service agreements with institutional customers, and business partnerships that required systematic communication about service continuity and relationship management during the ownership transition. The complexity of customer relationship management and communication coordination provided perfect justification for professional business representation, while concealing my actual involvement in customer relationship development and strategic account management throughout our business partnership. The employee management requirements that characterized Chen Industries' operations included payroll coordination, benefit administration, personnel management for over 150 employees across multiple facilities who required ongoing communication about business continuity and employment security during the ownership transition process. The systematic coordination required for employee communication and benefit management provide additional justification for professional business management, while concealing my actual experience with human resource coordination and employee benefit administration through my corporate career experience. The legal document organization that was required for estate settlement included corporate formation documents, property deeds, insurance policies, and financial account agreements that needed systematic review and coordination during the probate process. The apparent complexity of document organization and legal review provided Whitmore, Davidson and Associates with perfect justification for comprehensive legal coordination, while concealing my actual understanding of corporate documentation and legal agreement analysis through my executive experience with contract review and legal compliance coordination. The strategic planning requirements that characterized the estate settlement process included decisions about business operations, continuity, asset management, optimization, and long-term financial planning that would affect the estate value and beneficiary distributions over several years. Complexity of strategic decision-making and long-term planning provided additional justification for professional legal guidance, while concealing my actual expertise in strategic business planning and financial analysis that I had developed throughout my career in corporate financial management. Investment coordination, the communication management that was required during the estate settlement process included coordination with attorneys, accountants, financial advisors, business partners, family members, and regulatory agencies who needed ongoing updates about estate administration and business operations during the transition period. The systematic communication coordination required with dozens of professional relationships provided perfect justification for legal representation, while concealing my actual experience with professional communication management and stakeholder coordination through my corporate career in executive leadership and financial management. The crisis management requirements that characterized the immediate post-death period included urgent business decisions time-sensitive contract negotiations, and critical financial coordination that required immediate professional attention and strategic decision-making capability. The apparent crisis atmosphere and urgent decision-making requirements provided Whitmore, Davidson and Associates with perfect psychological pressure for immediate legal representation, while concealing my actual experience with crisis management and urgent decision-making through my corporate career in financial management during economic downturns and business transition. The emotional complexity that characterized my situation included not just grief over Richard's death, but anxiety about business continuity, concern about employee welfare, and responsibility for preserving the business legacy that we had built together over 4 decades of partnership. The legitimate emotional burden created by these circumstances provided authentic foundation for my apparent overwhelm and dependency, while concealing the sophisticated analysis and strategic planning that I was conducting about their systematic manipulation and criminal intent. The social expectations that influenced my situation included cultural assumptions about elderly widow capabilities, gender-based stereotypes about business management expertise, and professional expectations about legal representation during complex estate settlement. The systematic social pressure created by these expectations provided perfect cover for their manipulation, while concealing my actual professional background and analytical capabilities that made me uniquely qualified to recognize and document their criminal behavior. The geographic isolation characterized my situation included the location of our primary residence in a suburban Connecticut community where I had limited daily contact with business associates or professional colleagues who might provide oversight or guidance during the estate settlement process. The apparent social isolation created by these circumstances provided additional justification for professional legal dependency, while concealing my actual maintenance of strategic relationships with federal investigators and regulatory authorities who were coordinating with me about their criminal investigation. The media attention that surrounded Richard's death had been minimal, as his business success had been achieved through systematic growth and strategic development, rather than high-profile public activity that would create ongoing press interest in the estate settlement process. The lack of media oversight during the estate transition provided Whitmore, Davidson and Associates with perfect cover for their systematic manipulation, while concealing my actual relationships with investigative journalists and media professionals, who would later provide comprehensive coverage of their criminal prosecution and professional destruction. The timing pressures that characterized the estate settlement process included business deadlines, tax filing requirements, and legal obligations that created systematic urgency, requiring immediate decisions and professional coordination. The legitimate time pressure created by these requirements provided perfect psychological manipulation for their systematic control, while concealing my actual understanding of legal deadlines and regulatory requirements that I was using to coordinate the timing of federal investigation, initiation, and evidence collection. This comprehensive collection of circumstances that created the perfect foundation for their estate theft operation also provided me with ideal cover for systematic documentation of their criminal behavior, strategic coordination with federal investigators, and evidence collection that would ultimately expose their decades of elder exploitation to criminal prosecution and professional accountability. The same complexity that they viewed as opportunity for manipulation actually represented sophisticated business operations that I was fully capable of managing while conducting the most comprehensive investigation of legal fraud and elder abuse that any law firm had ever experienced through federal criminal prosecution and regulatory destruction. The sophisticated professional presentation that Whitmore, Davidson and Associates employed to gain my trust and establish their authority represented decades of refined manipulation techniques specifically designed to exploit elderly clients whose apparent vulnerability made them attractive targets for systematic estate theft disguised as compassionate legal protection. Their approach combined legitimate legal credentials with psychological manipulation, cultural exploitation, and systematic boundary testing that gradually eliminated client autonomy, while building comprehensive control over financial assets and decision-making authority. Thomas Whitmore's initial contact with me had been strategically timed for maximum psychological impact, occurring exactly 10 days after Richard's funeral, when grief would still be overwhelming my judgment, but urgent business decisions would be creating practical pressure for immediate professional assistance. His phone call had been perfectly calibrated to project paternal concern and professional competence, while emphasizing the urgent financial risks that delay in legal coordination could create for estate preservation and business continuity. Ms. Chen, he had said in his carefully modulated voice that projected both authority and compassion, I want to express my deepest condolences for your loss. Richard was not just a valued client, but a personal friend, and I know how devastating this must be for you. I'm calling because there are some urgent legal matters regarding the estate that require immediate professional attention to protect your financial interests and ensure business continuity. I understand this is an incredibly difficult time, but some decisions simply cannot wait without risking serious financial consequences for you and your family.
The strategic timing of his contact had been coordinated with his systematic monitoring of obituary notices, probate court filings, and business registration databases that enabled him to identify wealthy elderly widows whose circumstances made them attractive targets for estate management services. His research into Richard's business empire and our family's circumstances had been comprehensive enough to create the impression of genuine personal relationship and professional familiarity, while actually representing systematic intelligence gathering about asset values and exploitation opportunities. The professional credentials that Thomas Whitmore presented during our first meeting included a law degree from Columbia University, 30 years of estate planning experience, membership in prestigious legal associations, and an impressive client list that included successful business owners and wealthy families throughout the New York metropolitan area. His systematic presentation of these credentials was designed to establish both competence and trustworthiness, while concealing the systematic complaints, ethical violations, and regulatory investigations that had characterized his actual professional history. The office environment that Whitmore, Davidson and Associates had created at 450 Park Avenue was specifically designed to intimidate clients, while projecting wealth and success that would make their services appear essential for proper estate management. The mahogany-paneled conference room with original oil paintings, expensive Persian rugs, and floor-to-ceiling law books created an atmosphere of old money establishment credibility, while the strategic seating arrangements positioned clients as supplicants, seeking professional guidance from superior authorities. David Davidson's professional presentation complemented Thomas Whitmore's paternal authority, with technical expertise and analytical capability that made complex estate coordination appear impossibly challenging for anyone without specialized legal training. His systematic use of financial jargon, regulatory terminology, and legal complexity created psychological pressure that discouraged independent analysis while building dependency on professional guidance and estate management services. Davidson's background credentials included a law degree from NYU, an MBA from Wharton, and 15 years of experience in corporate law and estate planning, that he presented as essential qualifications for managing complex business estates and international financial coordination. His systematic emphasis on the sophisticated nature of modern estate law and the potential financial disasters that could result from inappropriate legal coordination created anxiety-based motivation for comprehensive professional representation. Patricia Kellerman's role in their manipulation system was specifically designed to exploit gender-based assumptions and cultural stereotypes about women's financial capabilities, while providing the appearance of female professional representation that might make elderly women clients more comfortable with comprehensive estate management services. Her systematic approach combined technical legal expertise with emotional manipulation that positioned estate planning as too overwhelming for grieving widows to coordinate in independence. Kellerman's professional credentials included a law degree from Georgetown, certification in estate administration, and 20 years of experience in probate law that she presented as specialized expertise essential for proper estate settlement and beneficiary protection. Her systematic emphasis on the emotional burden that financial coordination would place on my grieving process created additional psychological pressure for professional dependency, while concealing the systematic client exploitation that characterized her actual practice methodology. The systematic client assessment techniques that all three attorneys employed during our initial meetings included subtle psychological evaluation, financial investigation, and family dynamics analysis that enabled them to identify optimal manipulation strategies while assessing exploitation potential and resistance capability. Their coordination was sophisticated enough that each attorney gathered different types of intelligence while maintaining the appearance of professional consultation and compassionate client service. The financial investigation that they conducted during our initial meetings included systematic questioning about bank accounts, investment portfolios, business asset and property holdings that was presented as necessary information for proper estate planning, while actually representing comprehensive asset assessment for exploitation planning. Their apparent concern about protecting my financial interests concealed systematic evaluation of extraction opportunities and control mechanisms that would enable comprehensive estate manipulation. The family dynamics assessment that they performed included subtle questioning about my relationships with adult children, communication patterns with extended family, and social support networks that might provide oversight or interference during estate settlement. Their systematic evaluation of potential family involvement was presented as concern about beneficiary coordination, while actually representing strategic planning for isolation and control that would minimize external supervision during their estate manipulation. The psychological evaluation that they conducted included assessment of my cognitive capabilities, emotional vulnerability, and decision-making patterns that would influence their manipulation strategies and control technique. Their systematic observation of my responses to stress, authority, and complex information was presented as professional consideration, while actually representing predatory analysis of exploitation opportunities and resistance limitation. The cultural exploitation techniques that they employed included systematic use of language barriers, immigration status assumptions, traditional gender role expectations to build psychological pressure for professional dependency, while eliminating cultural confidence and community support that might interfere with their estate control. Their apparent cultural sensitivities concealed systematic exploitation of immigrant vulnerability and social isolation. The trust-building methodology that they systematically employed included strategic revelation of insider information about probate procedure, systematic demonstration of professional connections with court officials and regulatory agencies, and careful coordination of small favors and personal attention that created emotional dependency while establishing their authority and indispensability for proper estate coordination. Thomas Whitmore's approach to trust building included strategic sharing of confidential information about other high-profile estate cases, systematic name-dropping of prestigious clients and professional relationships, and careful demonstration of insider access to court procedures and regulatory coordination that created the impression of exclusive professional capability, essential for optimal estate management. Davidson's technical trust building included systematic demonstration of complex financial analysis, detailed explanation of regulatory compliance requirements, and comprehensive presentation of risk management strategies that created the impression of sophisticated expertise essential for business continuity and asset protection during estate settlement. Kellerman's emotional trust building included systematic expression of personal concern about my welfare, strategic sharing of experiences with other widows facing similar challenges, and careful coordination of practical assistance with daily coordination that created emotional dependency while establishing her authority over personal and financial decision. The boundary testing methodology that they employed included systematic expansion of their involvement in personal decisions, gradual increase in their authority over financial coordination, and careful elimination of external relationships that might provide oversight or alternative guidance during estate settlement. Their systematic testing of my resistance to control was presented as increased professional service, while actually representing predatory expansion of exploitation authority. The communication control techniques that they implemented included systematic monitoring of my correspondence with other professionals, strategic interference with family communication about estate matters, and gradual elimination of independent information sources that might contradict their guidance or reveal their manipulation techniques. Their apparent concern about communication coordination concealed systematic isolation strategies designed to eliminate oversight and resistance. The decision-making manipulation that they systematically employed included time pressure tactics that discouraged careful analysis, complexity creation that made independent evaluation impossible, authority transfer mechanisms that eliminated my decision-making capability while maintaining the appearance of voluntary professional delegation and protective estate management. The documentation control strategies that they implemented included systematic organization of estate paperwork under their supervision, strategic limitation, my access to original financial documents, and gradual transfer of important legal papers to their offices for secure storage and professional coordination that actually represented comprehensive information control and evidence elimination. The professional network interference that they coordinated included systematic communication with my existing accountants, financial advisors, and business consultants that positioned their legal services as superior coordination, while gradually eliminating external professional relationships that might provide alternative guidance or oversight during estate settlement. The urgency creation techniques that they employed included systematic emphasis on time-sensitive legal deadlines, strategic presentation of financial risks requiring immediate professional intervention, and careful coordination of crisis scenarios that made delayed decision-making appear financially catastrophic, while building psychological pressure for immediate estate management authorization. The fee structure presentation that they used to establish financial control included systematic explanation of estate management costs as necessary investment in asset protection, strategic comparison with potential financial losses from inadequate legal coordination, and careful justification of comprehensive fee arrangements as cost-effective professional service, rather than systematic financial extraction, disguised as legal representation. The authority expansion methodology that they systematically implemented included gradual increase in their decision-making responsibility, strategic presentation of complex legal requirements as beyond client capability, and careful elimination of client authority through progressive contract modifications and power transfer arrangements that were presented as improved professional service rather than systematic client exploitation. The client isolation techniques that they employed included systematic discouragement of second opinions from other legal professionals, strategic interference with family involvement in estate decision, and gradual elimination of community relationships that might provide alternative perspectives or oversight during their comprehensive estate control and financial manipulation. The emotional manipulation strategies that they coordinated included systematic exploitation of grief vulnerability, strategic use of guilt about Richard's business legacy, and careful creation of anxiety about financial security that made their protective services appear essential while concealing the systematic asset extraction and control that characterized their actual estate management methodology. The legal intimidation techniques that they employed included systematic use of complex legal terminology, strategic presentation of regulatory compliance requirements as impossibly challenged, and careful creation of legal crisis scenarios that made independent estate coordination appear legally dangerous, while building dependency on their professional protection and guide. The institutional credibility exploitation that they systematically used included strategic presentation of their court relationships, systematic emphasis on their regulatory connection, and careful coordination of official appearing documentation that created the impression of governmental authority and legal necessity, while concealing the systematic fraud and professional misconduct that characterized their actual practice methodology. The contract manipulation Strategies that they implemented included systematic use of complex legal language that obscured authority transfer mechanisms, strategic inclusion of automatic renewal clauses and fee escalation provision, and careful elimination of client termination rights through progressive contract modifications that were presented as improved legal protection rather than systematic client exploitation and financial control. The asset assessment techniques that they employed during this trust-building period included systematic evaluation of bank account values, strategic investigation of investment portfolio composition, and comprehensive analysis of business asset values that was presented as necessary information for estate planning, while actually representing detailed planning for systematic financial extraction and asset control. The resistance evaluation methodology that they used included careful testing of my responses to authority assertions, systematic observation of my compliance with their guidance and recommendations, strategic assessment of my independent information gathering capabilities that would influence their manipulation strategies and control techniques throughout their comprehensive. This sophisticated professional presentation and systematic trust-building operation created exactly the foundation that Thomas Whitmore, David Davidson, and Patricia Kellerman needed to establish comprehensive control over my estate while maintaining the appearance of legitimate legal representation and compassionate professional service. Their decades of experience in elder exploitation had taught them exactly how to project competence and caring while systematically eliminating client autonomy and building financial control that would enable comprehensive asset extraction, disguised as protective estate management. What they never suspected was that their systematic manipulation techniques and professional boundary violations were being comprehensively documented by someone whose 35 years of corporate financial management had provided extensive experience in detecting exactly their type of sophisticated fraud, systematic professional misconduct, whose regulatory relationships included direct contacts with federal investigators who specialized in legal malpractice and elder exploitation, and whose strategic analysis capabilities were already coordinating the comprehensive investigation that transformed their comfortable assumptions about elderly vulnerability into the most public and complete professional destruction that any estate theft operation had ever experienced through criminal prosecution, civil litigation, and regulatory accountability. The performance that I delivered during every interaction with Whitmore, Davidson, and Associates required me to draw upon not just my decades of corporate experience in managing complex negotiations and hostile stakeholders, but my deep understanding of psychological and cultural expectations and professional authority dynamics to create a facade of helpless confusion that was so convincing that even experienced legal predators never suspected they were being systematically analyzed and documented by someone whose professional expertise in financial crime detection far exceeded their capabilities in estate law and elder exploitation. The daily routine that I established during this period was carefully designed to reinforce every assumption they had made about my intellectual limitations and emotional vulnerability, while actually providing perfect cover for sophisticated evidence collection and strategic coordination with federal investigators. My morning routine began at 5:30 a.m., with comprehensive review of their previous day's activities, systematic analysis of their communication pattern, detailed documentation of their boundary violations and manipulation techniques, using encrypted digital systems that I maintained in a secure home office that they never suspected existed. The clothing selection that I employed for every meeting and interaction was strategically calculated to project elderly confusion and traditional cultural deference, rather than the professional competence that had characterized my corporate career. The simple black dresses and conservative cardigans that I chose created an image of traditional widow's mourning, while eliminating any suggestion of the sophisticated business attire that had been my professional signature during 35 years of executive financial management. My systematic attention to appearing physically diminished included deliberate selection of comfortable flat shoes that suggested mobility concerns, oversized clothing that created an impression of physical frailty, and minimal jewelry that reinforced the image of someone whose priorities had shifted from professional presentation to basic comfort and emotional coping. The reading glasses that I wore during meetings were actually unnecessary for my vision, but created additional visual reinforcement of age-related limitation and intellectual dependence. The grooming choices that I made during this period included minimal makeup that suggested fatigue and emotional overwhelm, simple hairstyles that appeared to reflect reduced attention to personal appearance, and occasionally visible signs of stress or exhaustion that reinforced their assumptions about my cognitive processing limitation and emotional fragility during the estate settlement process. The speech patterns that I developed for interactions with all three attorneys included systematic hesitation when discussing financial concepts, apparent difficulty following complex legal explanation, and communication uncertainty that convinced them they were dealing with cognitive processing challenges rather than strategic information gathering. My systematic requests for repetition and clarification were interpreted as confusion rather than evidence collection, while my deferential approach to their expertise reinforced their assumptions about my intellectual dependence. The vocabulary limitations that I displayed included apparent unfamiliarity with legal terminology, systematic confusion about business concepts that I had actually been using throughout my corporate career, and the kind of language processing challenges that convinced them my professional background had been limited to traditional domestic responsibilities rather than sophisticated financial analysis and executive leadership. The memory inconsistencies that I occasionally demonstrated included apparent confusion about business details that Richard had supposedly handled independently, systematic difficulty recalling specific financial arrangements and investment decisions that we had actually coordinated together, and the kind of cognitive processing challenges that convinced them they were witnessing grief-related mental decline rather than deliberate information management designed to encourage their overconfidence. My approach to note-taking during meetings was carefully designed to appear inadequate and confused while actually conducting sophisticated analysis of their manipulation techniques and criminal evidence collection. The simple notebook that I carried to meetings contained apparently confusing financial notations and legal questions that reinforced their assumptions about my intellectual limitation, while concealing the comprehensive digital documentation system that I was maintaining for federal investigation. The questions that I asked during meetings were strategically formulated to appear naive and confused while actually gathering specific evidence about their systematic boundary violations and criminal intent. My systematic requests for clarification about confusing legal procedures were interpreted as intellectual limitation rather than evidence collection about their manipulation of estate law and fiduciary responsibility violation. The emotional responses that I displayed during discussions were carefully calibrated to reinforce their assumptions about my vulnerability, while concealing the strategic analysis that I was conducting about their psychological manipulation. My apparent anxiety about financial security was interpreted as natural grief response rather than systematic documentation of their attempts to create dependency and eliminate autonomy. The decision-making hesitation that I demonstrated included systematic requests for time to think about their recommendations, apparent anxiety about making important choices without guidance, and the kind of intellectual uncertainty that convinced them my business judgment had been completely dependent on Richard's leadership, rather than recognizing my actual role as strategic financial architect throughout our business partnership. The technology struggles that I displayed whenever they attempted to involve me in electronic document review or digital communication were perfectly calculated to appear authentic while concealing my sophisticated expertise in financial software and database management. My apparent confusion about email coordination and electronic signatures positioned them as necessary technical facilitators, while I was actually using advanced digital security systems to protect my investigation from discovery. The financial management evidence that I presented in my home included apparently confused organization of estate paperwork, systematic difficulty maintaining filing system,
and the kind of administrative disorganization that suggested cognitive processing limitations, rather than the sophisticated financial analysis and criminal documentation that I was maintaining in secure locations throughout our property. My approach to banking coordination during this period included systematic preference for in-person transactions that appeared to reflect technology limitations and institutional confusion, while actually providing perfect opportunities for face-to-face communication with financial institutions' security officers who were coordinating with investigators about potential elder financial abuse and systematic estate manipulation. The investment knowledge that I displayed included apparent confusion about portfolio management and asset allocation principles, systematic difficulty understanding market analysis and financial planning concepts, and the kind of economic comprehension limitations that positioned their estate management services as essential professional necessity, rather than systematic theft disguised as legal protection. The business understanding that I demonstrated during discussions about Chen Industries included apparent confusion about operational details that Richard had supposedly managed independently, systematic difficulty following corporate financial reports and strategic plan, and the kind of business comprehension limitations that convinced them I had been limited to administrative support rather than strategic leadership throughout our partnership. The legal system familiarity that I displayed included systematic confusion about probate procedures and estate law requirements, apparent difficulty understanding court processes and regulatory court, and the kind of institutional navigation challenges that convinced them my legal understanding had been completely dependent on Richard's guidance and professional relation. The insurance coordination that I presented included apparent difficulty understanding policy management and claims procedures, systematic confusion about coverage details and beneficiary coordination, and the kind of insurance system navigation that suggested both cognitive limitations and institutional dependency, rather than my actual expertise in corporate insurance management and risk assessment. The tax coordination approach that I employed included systematic confusion about estate tax obligations and business tax requirements, apparent difficulty understanding IRS procedures and compliance coordination, the kind of tax system navigation challenges that positioned their legal services as essential professional coordination, while concealing my extensive background in corporate tax strategy and regulatory compliance. The property management evidence that I displayed included apparent confusion about real estate coordination and maintenance procedures, systematic difficulty understanding property tax obligations and management requirements, and the kind of property system navigation that convinced them my real estate involvement had been limited to domestic residents, rather than strategic investment and development plan. The vendor relationship management that I demonstrated included apparent difficulty coordinating service providers and professional relations, systematic confusion about payment procedures and contract evaluation, and the kind of business relationship navigation that suggested cognitive limitations, rather than my extensive experience in vendor management and strategic partnership development. The emergency preparedness coordination that I maintained included systematic anxiety about crisis planning and safety procedures, apparent confusion about emergency communication and response protocol, and the kind of crisis management that convinced them my safety coordination required apparent professional oversight, while concealing my sophisticated emergency planning and federal investigator communication system. The daily schedule management that I displayed included apparent difficulty maintaining systematic appointments and activity coordination, systematic confusion about time management and task organization, and the kind of routine coordination challenges that reinforced their assumptions about cognitive decline while actually supporting my strategic control over meeting timing and evidence collection opportunities. The social interaction patterns that I maintained during this period included systematic limitation of community involvement and professional relationships, apparent difficulty maintaining complex conversations and social coordination, and the kind of relationship management that suggested both cognitive processing challenges and emotional withdrawal rather than my strategic isolation for investigation, protection, and federal coordination. The household management evidence that they observed included apparent difficulty coordinating domestic arrangements and property maintenance, systematic confusion about service provider management and household organization, and the kind of domestic coordination challenges that suggested cognitive limitations, while concealing my sophisticated business analysis and criminal documentation system. The medication management routine that they occasionally observed included systematic organization of prescription coordination and health maintenance, apparent anxiety about medical procedures and healthcare navigation, and had health system management that reinforced assumptions about cognitive decline while actually reflecting my strategic emphasis on health documentation for legal evidence purposes. The transportation coordination that I displayed included systematic preference for assistance with driving and travel arrangements, apparent anxiety about independent navigation, and the kind of mobility management that suggested both physical limitations and cognitive processing challenges, rather than my deliberate strategy of controlling meeting locations and maintaining comprehensive documentation during every interaction. The communication management that they observed included apparent difficulty coordinating telephone conversations and correspondence, systematic confusion about message management and contact coordination, and the kind of communication navigation that suggested cognitive processing limitation, rather than my sophisticated, encrypted communication systems for federal investigator coordination and evidence share. The appointment scheduling that I demonstrated included systematic difficulty managing meeting coordination and calendar organization, apparent confusion about time management and scheduling procedure, and the kind of administrative coordination challenges that positioned them as necessary practical facilitators, while concealing my strategic control over meeting timing and evidence collection.
The contract review approach that I employed included systematic confusion about agreement terms and legal obligations, apparent difficulty understanding performance requirements and liability provisions, and the kind of legal analysis limitations that encouraged them to explain their authority, transfer mechanisms while providing detailed evidence of their criminal intent and systematic client exploitation. The financial planning coordination that I displayed included apparent confusion about investment strategy and asset management, systematic difficulty understanding economic planning and wealth preservation, and the kind of financial analysis limitations that position their estate management as essential professional service, while concealing my sophisticated analysis of their systematic asset extraction and control mechanism. The family communication management that they observed included apparent difficulty maintaining relationships with adult children and extended family, systematic confusion about family coordination and communication procedures, and the kind of relationship navigation that suggested both emotional overwhelm and cognitive limitations, rather than my strategic coordination with family members about federal investigation and evidence collection. The professional network coordination that I displayed included apparent loss of business relationships and industry connections, systematic confusion about professional communication and service coordination, and the kind of professional relationship navigation that convinced them I lacked external oversight, while concealing my active coordination with federal investigators and regulatory enforcement officials. This comprehensive performance of intellectual limitation and emotional vulnerability was so carefully constructed and systematically maintained that Thomas Whitmore, David Davidson, and Patricia Kellerman never questioned its authenticity. His every interaction reinforced the narrative they wanted to believe, while providing multiple confirmation points for their assumptions about elderly cognitive decline and professional dependency. The systematic nature of my evidence presentation created an unshakable foundation for their confidence in my limitation, while building their comfort with increasingly aggressive boundary violations and asset control mechanisms. What made this deception particularly effective was the combination of authentic elements, genuine grief over Richard's death, legitimate complexity in estate coordination, and real cultural background, with sophisticated performance techniques that I had developed through decades of corporate negotiations and stakeholder management. The emotional foundation was completely real, which made the intellectual limitations appear entirely plausible, while concealing the strategic analysis and federal coordination that I was conducting during every interaction. The systematic documentation that I was maintaining throughout this period included detailed video recordings of their manipulation techniques, comprehensive analysis of their contract language and fee structure, strategic coordination with federal investigators about their pattern of elder exploitation and systematic violation of fiduciary responsibility. The evidence collection that I was conducting was so sophisticated and comprehensive that it would ultimately provide federal prosecutors with the most detailed documentation of systematic legal fraud and elder abuse that any criminal investigation had ever assembled. The cultural exploitation that they were employing, their systematic use of immigrant status assumptions, gender-based stereotypes, and age-related prejudices, was being comprehensively documented for federal civil rights violations and professional misconduct charges that would complement their criminal prosecution for elder financial abuse and systematic estate theft. Their comfortable assumptions about my intellectual limitations and cultural deference were providing perfect evidence of the discriminatory practices that enabled their systematic client exploitation. The professional network that I was secretly coordinating included relationships with Securities and Exchange Commission investigators who specialized in financial elder abuse, white-collar crime prosecutors who had handled major legal malpractice cases, and regulatory enforcement officials who were already investigating similar elder exploitation networks throughout the legal industry. My systematic evidence collection was providing federal authorities with real-time documentation of their criminal behavior while building the comprehensive case that would expose their decades of systematic client exploitation. This masterpiece of strategic deception was creating exactly the overconfidence and boundary violation escalation that would provide federal investigators with the criminal evidence necessary for comprehensive prosecution, while protecting other elderly victims from their systematic exploitation. The more convinced they became of my intellectual limitation and emotional dependency, the more aggressive their criminal behavior became, and the more evidence they provided for their own destruction through federal investigation and professional accountability. The moment that would transform Thomas Whitmore, David Davidson, and Patricia Kellerman's comfortable assumptions about elderly vulnerability into the most comprehensive professional and personal destruction that any estate theft operation had ever experienced occurred on a cold February morning when they presented me with their final estate management contract that would transfer complete control over Richard's $80 million empire to their law firm, while reducing me to a monthly allowance recipient with no decision-making authority over assets that I had spent 40 years helping to build. The contract signing meeting they had scheduled was designed as their ultimate victory celebration, where the confused elderly widow would finally surrender complete financial control to their superior legal expertise. What they were actually walking into was a carefully orchestrated federal sting operation that I had been coordinating for 3 months with the Securities and Exchange Commission, the Federal Bureau of Investigation, and the Southern District of New York Prosecutor's Office. Miss Chen, Thomas Whitmore said with his characteristic patronizing smile as he placed the thick contract before me, "This comprehensive estate management agreement will finally give you the peace of mind you deserve. You won't have to worry about any complicated financial decisions ever again. We'll handle everything while you focus on healing and enjoying your remaining years." What Thomas didn't know was that the confused elderly woman sitting across from him was Eleanor Chen, former chief financial officer of Meridian Capital Management, who had spent the last 90 days systematically documenting their criminal operation, while coordinating with federal investigators to build the most comprehensive case of legal malpractice and elder financial abuse in New York State history. "Mr. Whitmore," I said, setting down my pen and looking directly into his eyes for the first time in months, "I think there's been a terrible misunderstanding about who you're dealing with." The confusion that immediately appeared on his face was nothing compared to what followed when I opened my briefcase and placed 3 items on the conference table: my business card from Meridian Capital Management, identifying me as Chief Financial Officer, a letter from the Securities and Exchange Commission confirming my cooperation in their investigation of systematic elder financial abuse, and a warrant from the Southern District of New York for the immediate seizure of all client files and financial records related to their estate management operation. "My name is Eleanor Chen, and for the past 35 years I've specialized in detecting exactly the kind of sophisticated financial fraud that you've been attempting to execute against my estate. What you perceived as confusion was comprehensive analysis. What you interpreted as dependency was evidence collection, and what you assumed was vulnerability was actually coordination with federal investigators who have been building a criminal case against your firm for systematic elder exploitation, legal malpractice, and professional misconduct. The color drained from David Davidson's face as I continued. Every conversation we've had has been recorded. Every document you've presented has been analyzed by federal financial crime investigators. Every manipulation technique you've employed has been systematically documented and is now part of a criminal investigation that includes not just my case, but 47 other elderly clients whose estates you've systematically stolen from over the past decade. Patricia Kellerman's hand was visibly shaking as she reached for her phone, but I was already ahead of her. I wouldn't recommend calling anyone just yet, Miss Kellerman. FBI agents are currently executing search warrants at your offices, your homes, and your bank account. Your phones are being monitored, your computers are being seized, and your professional licenses are being suspended pending criminal prosecution. The systematic documentation that I had been collecting for 3 months included video recordings of their manipulation technique, comprehensive analysis of their fraudulent contract language, financial audits, revealing their systematic theft from elderly clients, and coordination with federal investigators who had been building a multi-state case against elder exploitation networks, operating through prestigious law firms. The evidence that federal investigators had assembled included financial records showing over $12 million in stolen assets from elderly clients, recorded conversations, revealing their systematic targeting of vulnerable widows, and documented coordination with corrupt probate officials who facilitated their estate theft operations in exchange for regular payoffs and referral fees. The Securities and Exchange Commission investigation that I had initiated revealed that Whitmore, Davidson and Associates had been operating what amounted to a criminal enterprise disguised as legal services, systematically targeting wealthy elderly clients for comprehensive financial exploitation, while maintaining the appearance of prestigious legal representation and estate protection service. Thomas Whitmore's criminal background, which federal investigators had uncovered during their comprehensive investigation, included previous disciplinary actions for client fund misappropriation, multiple complaints for professional misconduct that had been covered up through political connection, and a pattern of targeting elderly immigrants and recent widows whose apparent vulnerability made them attractive victims for systematic estate theft. David Davidson's financial analysis revealed personal debts exceeding $2 million, gambling addiction that had been driving increasingly desperate criminal behavior, and coordination with organized crime figures who were laundering money through his estate management operation. His sophisticated legal knowledge had been systematically corrupted by personal financial desperation and criminal enterprise coordination. Patricia Kellerman's background investigation revealed a history of exploiting elderly women clients through emotional manipulation and financial dependency creation, previous employment terminations for ethics violations that had been concealed through legal industry networking, and systematic coordination with financial advisors and insurance agents who shared profits from elderly client exploitation. The federal investigation had also uncovered their coordination with corrupt probate court officials, unethical financial advisors, and criminal organizations that specialized in elderly financial abuse throughout the New York metropolitan area. Their law firm had been operating as the legal coordination center for a sophisticated criminal network that had stolen millions from vulnerable elderly clients over more than a decade. The civil rights violations that were documented included systematic discrimination against elderly clients based on age, gender, and national origin, deliberate exploitation of cultural barriers and language limitation, and institutional practices designed to exclude elderly clients from meaningful participation in their own legal and financial decision-making. The evidence collection that I had coordinated included comprehensive financial audits, revealing the full scope of their theft. Digital forensics analysis of their computer systems showing systematic client targeting and asset analysis, and coordination with federal prosecutors who specialized in white-collar crime and elder abuse prosecution. The criminal charges that resulted from the comprehensive federal investigation included multiple felony counts of elder financial abuse, systematic violation of fiduciary responsibility, professional misconduct, money laundering, and conspiracy to commit fraud. The sophisticated nature of their criminal operation resulted in federal charges that carried potential sentences of 25 years in federal prison. The professional consequences included immediate suspension of law licenses, placement on national databases, preventing future legal employment, and systematic investigation of every client case they had handled over the past 15 years. The state bar associations in New York, Connecticut, and Massachusetts initiated comprehensive reviews that resulted in permanent disbarment and civil penalties exceeding $5 million. The civil litigation that I initiated included comprehensive lawsuits against their law firm, professional liability insurance providers, and regulatory agencies that had failed to detect their systematic criminal activity. The financial settlements exceeded $20 million and provided compensation for dozens of elderly victims while creating institutional accountability that promoted systemic reform throughout the legal industry. The media coverage that documented their arrest and prosecution included detailed investigation by 60 Minutes, comprehensive reporting by the New York Times, and documentary coverage that educated the public about sophisticated elder exploitation methods while promoting awareness about legal industry accountability and regulatory reform. The institutional consequences included closure of their law firm, comprehensive investigation of similar operations throughout the region, and regulatory reform that strengthened oversight requirements for estate management services while implementing enhanced protection for elderly clients and systematic monitoring of attorney-client relations. The personal satisfaction that I experienced from coordinating this comprehensive justice delivery included not just accountability for their attempted theft of my estate, but protection of hundreds of other elderly individuals who might have been targeted by similar criminal operations. Institutional reform that strengthened elder protection throughout the legal industry, and professional fulfillment from using my financial expertise to protect vulnerable populations and promote justice. The long-term consequences for Thomas Whitmore included a federal prison sentence of 18 years, comprehensive financial penalties that eliminated his personal assets, and permanent exclusion from legal practice that ended his career in systematic elder exploitation. His prestigious reputation was transformed into a cautionary tale about professional corruption and criminal behavior. David Davidson received a federal sentence of 15 years, financial penalties that addressed his victim restitution obligations, and permanent prohibition from financial services that eliminated his capability for future elder exploitation. His gambling addiction and criminal desperation resulted in complete personal and professional destruction. Patricia Kellerman's sentence of 12 years in federal prison reflected her extensive cooperation with investigators about the systematic nature of their elder exploitation network. Her professional destruction included permanent disbarment and civil penalties that provided victim compensation while eliminating her capability for future client manipulation. The systemic impact of their prosecution included comprehensive reform of estate management regulations, enhanced background screening requirements for attorneys handling elderly clients, and institutional accountability measures that strengthened protection throughout the legal industry. The federal investigation had exposed weaknesses in regulatory oversight that enabled systematic elder exploitation while promoting comprehensive reform and institutional accountability. The community education that resulted from comprehensive media coverage included extensive public awareness campaigns about elder exploitation, warning signs, systematic training for family members, and community organizations about protection strategy and legislative action that strengthened criminal penalties for elder abuse while enhancing institutional oversight and accountability. The professional legacy that I established through this comprehensive justice delivery included recognition for using corporate financial expertise to protect vulnerable populations, institutional relationships with federal investigators that promoted ongoing elder protection efforts, and educational coordination that helped train financial professionals about elder abuse detection and prevention. The ultimate lesson that Thomas Whitmore, David Davis, and Patricia Kellerman learned through their comprehensive prosecution was that elderly individuals often possess sophisticated professional capabilities, extensive institutional relationships, and comprehensive resources for justice delivery that can transform apparent vulnerability into powerful accountability and systematic criminal exposure. 6 months after their sentencing, I established the Richard and Eleanor Chen Foundation for Elder Protection, using the recovered assets and civil settlement funds to provide legal assistance for elderly victims of financial abuse, educational programs for professional elder care providers, and legislative advocacy for enhanced elder protection and institutional accountability. The Foundation's work includes coordination with federal investigators to identify and prosecute elder exploitation networks, educational outreach to elderly communities about protection strategies and warning signs, and institutional advocacy that promotes systematic reform and regulatory accountability throughout industries that serve elderly populations. The professional relationships that I developed through this investigation continue to provide ongoing coordination with federal authorities about elder protection, systematic collaboration with legal professionals who specialize in elder advocacy, and institutional partnerships that promote comprehensive protection and justice delivery for vulnerable elderly populations. Remember, respect and protect elderly individuals, not just because it's morally right, but because you never know when the vulnerable elderly person you're exploiting might actually possess the professional expertise and institutional connections necessary to transform your criminal behavior into federal prosecution and comprehensive professional destruction. What would you have done if attorneys were trying to steal your family's legacy? How do you think we can better protect elderly family members from systematic legal exploitation? Drop your thoughts in the comments below, and if you found this story of justice inspiring, make sure you're subscribed, because next week, I'm sharing the story of how a helpless nursing home patient who was being systematically drugged and robbed turned out to be a retired federal prosecutor, and what happened when she called her former colleagues at the Department of Justice for a surprise facility inspection that changed everything. The satisfaction of watching their faces transform from condescending confidence to complete terror as they realized exactly who they had been attempting to exploit provided the perfect conclusion to their systematic abuse of elderly trust and dignity. Sometimes the most powerful lesson about respect comes from discovering that the person you've been underestimating possesses exactly the expertise and connections necessary to ensure that justice is not just served, but comprehensively delivered with the kind of institutional accountability that protects countless other victims from similar exploitation and abuse. They made me feel invisible, so I made them disappear with everything they had stolen, everything they had built through criminal exploitation, and everything they thought they could take from elderly people who deserved protection, respect, and justice, instead of systematic abuse and financial theft disguised as professional legal service. Up next, you've got 2 more standout stories right on your screen. If this one hit the mark, you won't want to pass these up. Just click and check them out. And don't forget to subscribe and turn on the notification bell so you don't miss any upload from